Hello and welcome to our second Breakup Breakdown session. Today we're joined by some experts from Westgate Chambers. We've got Trina Little and Ayisha Robertson. Trina is continually instructed on high net worth cases that demand complex financial analysis and cases involving undisclosed assets and pensions. She also works on child arrangement cases, and she's got expertise in dealing with cases that include coercive control, specific issue, and prohibited steps, as well as parental alienation. And we're also joined by Ayisha, and she works within care proceedings and also private law child arrangements, and she also accepts instructions from direct access. She is continually instructed on private law cases representing mothers, fathers, and children via their guardians. These cases often involve allegations of coercive control, international and cultural elements, removal from the jurisdiction, and parental alienation. She's particularly passionate about ensuring domestic abuse cases are heard and tried fully and properly so the victims receive the full extent of the justice they deserve. So, welcome to our Breakup Breakdown session.
Hello, good afternoon.
Hi.
Thank you so much for joining us.
Well, thank you for having us.
So, we've had some questions put in from social media. We asked if people wanted to use this opportunity to put forward some questions because it's kind of it's a great opportunity for people to have this access to you guys and to be able to have this opportunity to speak to you. So we've had some questions coming in and we're going to put them to you if that's okay.
Of course, thanks ever so much.
So should we start with the children's side of things and with you, Ayisha, is that okay?
Yeah, absolutely.
Yeah, and I think Tara's going to ask you those questions.
Hello, and thank you for joining us. We've had quite a few children-related questions because obviously it's quite an emotional time, and people don't always know the correct places to look for this information. And it'd be really good to hear from you as the experts as to what they can expect going forwards. So we've got one that was quite interesting, and it said, "Hi, just a quick question. I'm in my right, I think it's meant to say am I, but it's am I in my right to say my children's mother to request that overnight stays to stop and see them for a couple of hours each on alternate weekends because of being cleared of allegations brought up by the children, which stopped me seeing them on an unsupervised weekend. Now cleared of them, she has insisted I can see them again unsupervised."
First of all, I want to extend my empathy to anyone that is going through a really difficult time at the moment. It is very difficult. Christmas and the lead up to it is incredibly difficult, and we often see a rise in concerns around that time, and also post summer, which has often led to quite a lot of conflict between parents about division of time. Child contact is a particularly difficult and emotive issue, and when it comes to the cessation of contact, a number of issues arise out of it. I want to stress I'm not here to give you legal advice. If any of the people who have written in need formal legal advice, please come and contact one of our two lovely solicitors here, Tara or Robyn, who will help you, or any other solicitors that we have in Sussex. And equally, if you do feel like you're a victim of domestic abuse, please seek help and make yourself safe. That's really important. When it comes to the cessation of child contact on the back of allegations of domestic abuse or other welfare concerns, there are a number of stages that have to be gone through. First and foremost, if you're not in proceedings as of yet, as a parent, you have a duty to safeguard your children. If you have genuine safeguarding concerns for the welfare of your children, which are significant and serious, it can't just be little Johnny came home and he hadn't had dinner tonight and he was a bit hungry, or daddy gave him a McDonald's and I don't like giving them McDonald's. It has to be something significant, which actually causes you genuine concern for the welfare and safety of your child. Then it is your duty to act upon that and to keep your child safe. And if you think it is proportionate to the risk that you feel your child is exposed to, it is appropriate to stop contact. I would suggest that if you feel you are going to take such a significant step, you do so with the support and advice of professionals such as solicitors, or maybe a social worker if you have a social worker involved, and if the school is aware of ongoing concerns and welfare risks as well. It's very difficult to make a decision like that independently, so please be very careful before doing it. A court's primary position will always be that a child should have a healthy relationship and a safe relationship with both of their parents. So even if in the short term you want to stop that contact and pause that relationship, you must have really good grounding to do so, because the court's not going to look particularly favourably on it. What you can do if you feel you need to stop contact is simultaneously make an offer of supervised contact, because in my practical experience, there are very few risks to a child that can't be ameliorated in a professionally supervised contact centre. And at least at that stage, you're saying, well, look, there is a risk, but I appreciate and respect the importance of this relationship between mother and child or father and child, and that relationship must continue, but it must be safe. It's then, of course, on the other side to see whether or not they want to take up that offer. They may take legal advice and want to take a different stance. So that's stage one. Stage two then is very promptly the issuance of proceedings. Issue proceedings clearly outlined, hopefully with the support of a solicitor, because this is a really critical stage. There are lots of different forms you have to fill in. One of them is called a C1A. That C1A outlines all of the allegations that you wish to make against your ex-partner or ex-husband or wife. And that's the foundation. That's the start of risk analysis for CAFCAS and for the court to determine what they consider to be a safe relationship between child and the non-resident parent. So if you can fill in that form and you can afford it, please do take legal advice on that stage, because it's really important that you do so. That's the second stage. The third stage is you then get to court, by which time CAFCAS has ideally picked up the phone to both parents and said, right, what's going on? What's happening? They then write what's called a safeguarding letter to the court, which does a short analysis of all of the risks in the case and makes brief recommendations to the court of what should happen. And that will be in line in terms of contact. That would be in terms of what needs to happen going forwards. Are the allegations so serious they actually need to be tried in what's called a finding of fact hearing? And if so, how do we achieve that? So that stage, I think we're on stage 3 now. If you are already in proceedings and allegations are made against you, or equally, you are a parent and your child comes back and says, while I was seeing mummy or daddy, this really serious thing happened and it's made me scared, it's made me fearful. Hopefully you've got a legal team behind you. My strong view is don't knee-jerk into stopping contact. Take a pause, take advice, see what the risk really is, see how that risk can be ameliorated. And if your only option is to stop contact, then do it, because you must keep your child safe. But if there is another way of managing that contact, if it is, okay, look, let's take a pause for a couple of weeks. We've got some play therapy going on. So let's let little Annabelle work through this in play therapy, see how she feels at the end of it. I'm all about being child-led, child-focused, and not trying to impose our own, as parents, concerns, anxieties, fears onto our children. Our own anxieties, fears, concerns about our lived relationships and our experiences in our relationships are incredibly valid, but they are separate from those in relation to your child. And the risks to you and the risks to your child will be managed appropriately within proceedings. We have this thing called Practice Direction 12J, which doesn't just assume that contact should happen between parents and child, but which says contact should happen if it's safe for the child, but also safe for the parent who is or for both parents who are providing that children up for contact with the other parent. And those risks around the interpersonal relationship between the parents can be managed in the court systems as well. So don't knee-jerk into stopping contact. Speak to your legal team, take advice. If you've got CAFCAS on board, which hopefully you do by then, speak to CAFCAS. And if things are so serious, you can ask CAFCAS to do an interim report on any cessation of contact or variation of contact. But that should be done via also an application to the court. And if you need to, you can ask your legal team to make an urgent application to court to have the variation of contact heard. So that's quite a broad answer to quite a specific question, but I hope that helps. The headline has to be, if you're concerned, then take legal advice, act appropriately in accordance with your child's welfare, and use the system that you have available to you to make sound, informed decisions in accordance with judicial recommendation. Well, CAFCAS recommendation, judicial decision.
Thank you so much. That's really helpful to have such a broad idea of how the system works. And I think it's really important that you've hammered home there that it's got to be really about the welfare as opposed to conflicting parenting styles.
Absolutely.
Like I think you have it on the head when you said about the McDonald's thing, and you've obviously different parenting approaches, and that can just be because of their own feelings and emotions, the tip of the iceberg, that, and it takes it far too far, and then the children become the victims of it.
Absolutely right. And interestingly enough, I was talking to Dr. Kay Pascoe about this and the impact of parental conflict on children's emotional and social maturation. And the impact is really, really huge, and no one wants to take away from parents the difficult lived experiences they've had, and all the cases, Tara, that you and I deal with, one or all, but most, there is a significant element of domestic abuse, and you can really understand parents' caution and trauma in itself.
Completely.
But that has to be dealt with separately from the child. Absolutely. It's all about children's welfare. And it can be really difficult in court when you're hearing a judge going, yes, but I'm here to think about child X and child Y, and I know that if I put in third-party handovers and you don't have to come into contact with each other, that you will be safe. But child X and child Y needs to have a relationship with mum or dad, and that's really, really important.
It's very difficult often to say just because your relationship has broken down doesn't mean the child and the parent relationship has to break down as well.
Absolutely.
And break that through.
So hard, but trust us as well, because we've done this for years, haven't we? We do know what we're doing, and we do see the outcomes. And I think clients probably stay in touch with you, Tara, more than they stay in touch with me, because I come to things at a slightly later stage. But certainly, I do know very happy outcomes where parents have been in really difficult and horrible situations, but actually the children have survived because the parents have managed to really focus on them, which is credit to them. It's a huge, huge skill.
Absolutely. Following on from that, I've got another question that's regarding the children, and it's I finally got my prohibitive steps order. They want to know, is this until the children turn 18? If the non-resident parent contests this, does the prohibitive steps order stay in place unless the judge says otherwise?
So that's a really difficult question to ask just on its fact. On one of so prohibitive steps orders, for those who don't know, is, as it says, a prohibition upon someone from doing something. So you can get a prohibitive steps order for anything that impacts someone else's parental responsibility. It could be, for example, mum thinks that school Y is better than school X, so has made a unilateral decision to remove child from school Y and make an application to school X. And dad goes, hang on a minute, that's not right. I need a say in this. And actually, I'm not sure that our current school really is that bad. And we need to discuss this and make a decision together. So you can get a prohibitive steps order for that, or changing a child's name, or you think that one of the parents is going to relocate and not talk to you about it. You can stop a parent from relocating. So it's difficult to know the basis on which that prohibitive steps order has been made. They usually have a duration to them. You should be able to see on the order as it's being drawn the expiration date of that prohibitive steps order, and otherwise it might say until further order. Now, usually that will mean, and the person who's asked this question will know, that an application has been made, the application has been heard, and has been granted in the interim. So not finally, but just for now. There will then be subsequent hearings after people have filed statements and evidence, and there may be a trial on the facts. So is school A really better than school B? What is the impact on child of moving from school A, where they've been since they were at nursery and gone through primary school, and it's a feeder into a senior school, and they've got lots of friends, and it forms a huge part of their identity, versus moving school to a school where they don't have any friends and is outside their locality, so they can't just walk, or they've got to get on a school bus and there's a huge amount of upheaval, or whatever it might be. And there's normally a trial where there's a dispute between parent A and parent B, and then a court will decide what they think is best for a child. Now, usually if this is happening within private law proceedings, CAFCAS will also have a say. They will speak to the child, they will speak to the parents, they will undertake any necessary and relevant inquiries, and then file a short report based on that as well. So check your order and see if the order states when it's going to expire. And you will know if you're still in proceedings, whether or not there's likely to be a further hearing. And the short answer is yes. If your partner or ex-partner doesn't agree with your decision making, they do have a right to contest that, because they have Article 6 and Article 8 rights. But your child will be heard fairly by a family court judge.
That's great, thank you. I would urge people to strongly think about whether that such an application is necessary,
Absolutely.
because I'm sure you'll be able to explain that the backlog at the court for hearing these things, you can often make the application to stop a child changing schools, and the court date will be so far in advance the child will either miss a period of school, or it just, it won't be done quick enough to stop what you're trying to achieve.
Absolutely,
which
right.
is quite frustrating. So would urge parents to think whether or not there is any other way of dealing with it as opposed to making that application.
And there are out of court resolutions, there's mediation. There is, even if you have been a victim of domestic abuse and you don't feel safe to be in a room, you can do shuttle mediation with the support of solicitors. There are other routes you can take to resolve disputes. For those parents who are just having a bit of an argy-bargy, again, I say this to all of my clients and I upset so many of them when I do it, but it's like, you loved each other once, you married each other, you had children, you made a commitment for life, and because you two have decided not to be together anymore, your commitment to co-parent, unfortunately, is still there. So where it's safe to do so, work together. And there are wonderful parenting apps out there that help with language monitoring and just help take some of the heat out of conversation by making it one step removed and putting it through a parenting app. And of course, the parenting apps also provide a level of security, or some do provide a level of security, because they're also admissible in court, which is really helpful.
Definitely. Okay, staying on with the children side of things, the next question is it illegal for my ex to stop contact with kids after being advised from a MASH team whilst the court case visitation is still live?
So that goes back to our first question, I think, doesn't it? And actually, if you are a survivor of domestic abuse, you do find that there are a number of different agencies that become involved with it. You can have an IDVA, you can have MASH, you can have the police, you can have children's services, and you will find that there is an enormous amount of pressure from those services to do the right thing. And there'll often be quite explicit advice given orally, but not a great deal written down. And ultimately, it comes back to, well, you're a parent. You have parental responsibility. If you feel it's in your child's best interest and welfare interest for that contact to be stopped, you have the right to exercise that parental responsibility. But I go back to all of those cautions initially. And if you are in proceedings, which this case sounds like it is, then the proper course of action is to go through your solicitors, to make an application to vary or cease contact, and to have that application heard, and where necessary, have CAFCAS's assessment of the situation, any risk that it can assess now, or those allegations form part of a future fact-finding hearing, which you'll have to undertake before decisions can be made around contact. Courts do take welfare. Well, welfare is our paramount guiding principle. So parents, be rest assured, sometimes it feels like the court system is working against you, but trust in it and use it, because if you don't use it appropriately, the court system equally doesn't like it very much.
That's really helpful, thank you. I know it's kind of picking up on the first question we had as well, which is a nice link. We've talked obviously about domestic abuse and in relationships. So from that, I've got another question regarding restraining orders. And it is, what should I do if someone has a restraining order against me, but they move to a place I pass every day and I can't easily avoid? It's been over a year since the police were involved and I haven't heard from her or her lawyers. I also made sure to stay away from the original property as required by the restraining order. She even drove by my house and called the police to get the original order because she filmed me walking near her new place outside the restricted area.
So the first
really tough one, isn't it?
It is a really tough one. But the first distinction to make is a restraining order. It is not something that's imposed by family courts. So they are born out of either criminal convictions or they are imposed without convictions. So something's happened, or they've admitted guilt, or there was a warning, and in order to keep the survivor safe, the police suggest that maybe a restraining order should go in place. They work much like non-molestation orders. They often put in zonal orders and say person Y can't go within 100 meters of this person, or contact them directly or indirectly, and can't contact them via social media, can't go to their home or any place they know or believe them to be living. There are all sorts of different conditions you can put in, but often they mirror those of non-molestation orders. So the first thing to do again is check the date on the restraining order. It will have an expiration date on it. If the date has been and gone, then the sound advice has got to be, or the logic has got to be, don't do the thing that she didn't want you to do, because it's going to get you into trouble even without a restraining order in place. So be very mindful. If the restraining order is still in effect, go to your criminal law solicitors and they can make an application to the court to vary it. Because at the point at which the original restraining order was made, it sounds like this person's everyday life wasn't being impacted by the imposition of the restraining order. But if the survivor has now moved and is now living, on the high street next to his work, that's going to be really tricky for him to manage. And he'd be well within his rights to go back and go, look, I agree not to go to or enter any property that she's living, but I can't physically stay 100 meters away from the property because it is right next to where I work, or it's right next to where the kids go to school, or or whatever it is. I suppose my particular word of warning has to be, how do you know where she's currently living? Has that information come to you through appropriate means? Be very mindful of your own conduct and any continuance of any patterns of behaviour that you might not be consciously aware of. The restraining order is there for a purpose, and it has been put in place as a result of conduct that has been unacceptable. And it's important to reflect on that and to move forwards and to grow.
And can I just add on that? And a breach of a restraining order is dealt very, very harshly with the courts. There's very, very serious penalties, including prison time. So really make sure you've got your ducks in a row there. You don't want to be on the other end of a breach of a restraining order.
Absolutely right. Absolutely right.
Yeah. I think it's also very important. We've had quite a few questions about timeframes and things, and often I think people don't look at the orders. They hear what's happened and they've got what I want, but they don't actually look at when they expire or all of the provisions in them. So I think a good thing to say is, please look at the orders, look at all of the fine print and make sure you've read it all and you know what's in there.
Quite. And there's a real drive in courts now to write and speak in plain English. So the orders should be reasonably understandable. And there should be headings that say, duration of the order. So it should be quite clearly signposted on the face of the order. So that's the order itself. Sorry, I'm speaking in jargon now, aren't I? Which is helpful. But on the order itself, there should be headlines. You can do this, you can't do that, and how long is it going to last for? So do take a moment to read them. You're absolutely right, Tara.
And if you are in court and you've got the order or whatever, and any of it's not clear, ask while you're there. Don't agree to things without knowing what you're agreeing to.
Totally right.
It would really have a terrible effect on you. It could be that this restraining order highlighted they could go in this area and they knew they were going to move and they just didn't know it at the time.
Yeah, absolutely right.
So going from the criminal side of it to the family court side of a non-molestation order, I've got, what happens at a return to court hearing for a non-molestation order if my ex tries to get it revoked? Am I allowed to provide evidence why shouldn't this be the case? Or does that come later?
So it sounds to me like an application has been made what we call ex parte, so not on notice to the other side. So it sounds like someone has made an application, the court said, look, I believe I'm at serious risk of harm from person B for X, Y, and Z reason. And this person can't know about this application because if they do so, I might come to harm or this application might be undermined in some way. Of course, in those circumstances, then hears that application and reads the evidence that it has before it, which won't be very much at that stage, and says, yes, on the face of it, I think you are at risk. So I am going to grant a non-molestation order. And again, sometimes courts do it just until the next hearing, the return hearing, or sometimes they do it until further order, which as a general rule means until the conclusion of proceedings. So at the return hearing, the respondents to the application, so the person against whom the non-molestation order has been made, will have to attend court as well. So the first thing to say is, if you are scared, you can apply for special measures. You can enter that court building at a different time, different way from the respondent. You can have a different waiting room. And if you're in court with that person, you can have a screen up so you don't have to see them. So that's the first thing. At your return hearing, if you're genuinely scared or you don't feel you can participate in that hearing properly without additional support, make an application to the court for special measures. At that hearing, the respondent to the application might be legally represented, which actually probably would be quite helpful, particularly if you're an applicant and you're doing it in person. So it means you haven't got to speak to the respondent themselves. It means you can speak to their barrister or their solicitor, whoever is there to support them. And they might try and resolve things by way of what's called undertakings. So a non-molestation order is an order of the court. It's a fairly draconian order because it stops you from doing things. And a non-molestation order, if you breach it, like a restraining order, is enforceable through police action and arrest and then criminal proceedings. Undertakings are different. They are a promise that respondent makes to the court not to do something. And the promise will be in exactly the same terms as the non-molestation order. But the difference is that it's a civil matter. So if the promise is not to go to your house and you have an undertaking and the respondent turns up at your house, it's your responsibility as the applicant to obtain evidence of the breach of the undertaking and to bring it back to court for contempt proceedings in front of a civil court. Now, the outcome and the possible sanctions available under an undertaking is actually the same as a non-molestation order. So you can be imprisoned, you can be fined, you can be given community service. So the repercussions are just as serious, but the mechanism for proving it is different. So if the other side comes to you and says, would you like undertakings? You need to think about the difference very carefully. If you can, and often I will stress, these proceedings are resolved by way of undertakings. It is often quite suitable for that to happen. Sometimes it's not. And particularly where there's a risk of violence involved, the law is quite clear. In fact, you shouldn't accept undertakings where there is a risk of violence involved. But if the respondent to your application disagrees with what you say and says, actually, no, your allegations are false or inaccurate in some way, then you'll both be asked to file evidence. And then you will come back for a final hearing where the judge will hear evidence from you and from the respondent and any witnesses that they've said can also give evidence. Don't forget, you're in the family court, so the standard of proof is different. The court just has to be 51% certain, effectively, that something has happened, rather than be beyond reasonable doubt, as you have to be in the criminal courts.
And I think just into that, I think some people with a non-molestation order, it comes with the power of arrest. So if you feel someone's breaching that order, you can ring the police and they can be arrested, whereas they don't have that power with undertakings. You can still, as Ayisha said, the remedy is still the same, but it's a bit more of an immediate response. And I think particularly in domestic abuse situations, people like to have the comfort of that. Knowing that they can ring the police. Obviously, you can ring the police anyway. If someone's doing something illegal, you can always ring 999 anyway if they're harming you in some way. So, but that's just another sort of slight difference.
Absolutely.
I think when there is quite a high risk of violence, then the order is much preferable to the undertakings. Because, like Trina said, you can phone the police and say, "I've got this order. He's breaching it," and they're more likely to do something quicker.
Absolutely right.
I was going to pick up on your bits about the safeguarding if you would go to court for the return date, in that obviously the courts can now do things remotely as well.
Yes.
So I've had a few cases where the victim has been able to attend remotely, but with her camera off, and the respondent is allowed to be there in person. And that's worked quite well at reassuring the applicant.
Absolutely. And actually, you can even attend remotely from the court building. They can set you up in a conference room so that you're there for discussions, and it makes the back and forth easier. But you don't actually have to be in the courtroom with them. But yes, absolutely. But it all has to be arranged in advance. Yeah.
Carrying on with the technology, we've got another question, and it's: my ex has secretly recorded an argument at home, and he used it as evidence to show that I'm aggressive and abusive, but he's actually the one at fault. What will the court think? I have so many questions like this on day-to-day practice. It'd be really interesting to hear from you on this.
Yes.
He's recorded me, she's recorded me. They just did it on purpose to goad me, and it's a real bugbear.
It's such a minefield as well, because actually they have value, but also they really don't have value, these sorts of recordings. And now where you can on your iPhones just timestamp change things, they hold very little evidential weight now at all. As a general rule, covert recordings is a big no-no. Don't do it. But Tara, as you've just highlighted, we see it in so many of our cases. It can form part of the evidential tapestry of a case. And depending on the context in which it was taken, the length of the video and the other evidence in the case, the court will weigh it all up and do whatever the court is going to do with it. And sometimes it's to look quite disparagingly on it, and other times it's to actually consider that it's quite useful evidence. Again, without seeing it, without knowing the other evidential matrix, it's quite hard to comment. But as a general rule, covert recordings are not helpful.
Yes, and sending them to your lawyer to watch over and over again is also not helpful.
No, don't do that. Or me.
And this is the last question I've got from my ones. And again, it's one that I hear all the time. How do you address your ex telling lies during court proceedings?
Oh, I mean, and it's so frustrating because what is a lie? And where does the truth actually lie? Essentially, we all approach, and I'm sorry, I'm being kind of psychological about this rather than legal, but inevitably we all perceive life through our own lenses, our own biases, our own lived experiences, our own traumas. So our truth is never really the truth. So the truth always lies somewhere between what two people are saying, inevitably. And that's not saying anyone is explicitly lying, but inevitably. We deal with lies in evidence all the time. I mean, it's just I mean, if people didn't lie, we wouldn't have final hearings. If people,
this is very true.
Or if people, and don't forget, people lie for different reasons. People don't necessarily, and we have this thing called a Lucas direction anyway, which deals with that. But just on a social level, people lie for different reasons: for embarrassment, through shame, because actually they find it difficult to perceive the truth themselves because of their own biases and everything that we've discussed. So it will be dealt with. What you have to do is stay true to your truth. And this is what I say to all of my clients, is what you're going through is incredibly difficult and painful, but openness, honesty, clarity, and reflection. None of us are perfect either. There is often no smoke without fire. And, if you can look at your behavior and go, actually, do you know what? Maybe I did react inappropriately. I did pick up that glass and chuck it across the room because I was really angry. And I look at that now and I see A, how dangerous it was, and B, how terrifying that must have been for the other person. But it was a moment that was out of my character or whatever. If you can reflect, do, because actually, ultimately, in all of these private law proceedings, you're not going to ultimately escape each other. I have had one case in my entire career so far where no contact has been ordered. And in fact, that case is currently back in now. I think we're 4 years down the line because the father in that case actually has made some significant changes. So the chances of you being totally free of your ex-partner for the remainder of what is effectively your life is minuscule. So these proceedings actually, and this is the hardest thing in the world to do, but these proceedings actually are an opportunity to draw a line and to take a step back, to accept some culpability, to reflect and actually try and repair. And our system is inherently an adversarial one, but we are very, very slowly tiptoeing away from that now and into more inquisitorial styles of advocacy and more inquisitorial styles of courtroom etiquette. And by that I mean it's exploratory. It's, well, what did happen? Well, why did it happen? Rather than having perpetrators and victims and aggressors and abusers, which just sets everybody up for conflict forever. And it's fine for you and I because we walk away at the end of these proceedings, even the ones that drag on for years. But the children in those proceedings are still only 7, 8, 9, 10, 12. They've got graduations, they've got changing schools, they've got marriages, they've got births, they've got deaths, they've got a whole life ahead of them, which you're going to have to negotiate with your ex-partner. So if you can, try and take a step back and reflect. Try and approach these proceedings with a degree of understanding as to why someone might be lying without just immediately assuming that they're doing it to be vindictive. Of course, there are people out there who are. You know, inevitably, we don't sadly live in a wonderful world where everyone tries their very best for each other. People do actively lie for their own personal gain and betterment, but a court will be dealing with that, and the court will listen to the evidence, compare it to the other evidence in the case, and they have the benefit of people like Trina and I in court going, well, hang on a minute, you said A on day 1, but by day 5 you'd said something completely different, and here's a text message that actually supports what you said in day A, so clearly what you said in day 5 is not true, is it? You know, that's why we are there to pull apart the evidence, to do the forensic analysis of it, and to pick apart those lies and to present them to the judge. Ultimately, lies undermine credibility. Lies also go to welfare. If the other person can't be worked with in an honest and open way, that does have an impact on your child's welfare. Can you trust this person? You know, if your child falls over and hurts themselves or is exposed to something online that they ought not to have been, can you trust them to communicate that to you? So it does. So credibility and honesty does directly also feed into welfare. So it is an important issue that the court will take very seriously.
Just don't lie. We're here to help you.
Exactly. Yes, exactly.
That's the thing. Don't lie to your representatives. We want to help you. We want to get the right outcome for the family. I really like that you've touched on how the court's coming away from the draconian adversarial.
Yeah.
3, 2, 1 adversarial approach, because I think it's really important that people know that when they step into the courtroom now, it's not the Rottweilers going at each other, and there is more of like a holistic approach, really, where people are being encouraged to explore all the alternatives out of court.
Absolutely.
And there's even the new practice direction that's come in that says at every step you should always explore that. If at this stage, is it appropriate to go to mediation? You know, is it appropriate to go to child inclusive mediation to see what the children want? And I like what you touched on also about how, you know, think about your children's graduations, their marriages and things like that. And a question I always like to ask is, how do you want your children to remember these years of their lives?
Yeah,
So
absolutely.
I think it's really important for people to remember that as the focus when
Absolutely.
they're thinking, oh, shall I make up this little lie just to get one up on them? Because
Absolutely.
it can just antagonize the situation when it doesn't need to.
It doesn't need to, absolutely, and all it does is undermine more trust, and it just erodes at that relationship even more. And regardless of whether you're together or not in a physical sense, you're still modeling parenting behaviors to your children. They are learning how to be parents by looking at you too. So if they see wars and if they see lies and dishonesty and a lack of respect, that's what they're going to take into their future relationships with them. And either they will be victims of that sort of behavior, or they will enact that sort of behavior, and just in this world of toxicity, it's your job to break the cycles that you might personally be stuck in or your relationship is stuck in.
We went off a bit of a tangent then, didn't we? Came away from the legal world back into the
There's my flag.
That was brilliant. Thank you. That is the end of the questions that I've got for you. So you're now off the hook. I can turn over to Robyn. Thank you so much, Ayisha. That's brilliant.
That was really interesting. I really enjoyed listening to that and Ayisha answering those questions. We're now going to ask Trina a couple of questions about the financial remedy side of court proceedings. So we've got a couple here. The first two that we've got in our list are we're actually going to put together because they're both about the start of the process in financial remedy proceedings and when you're ordered to disclose a Form E. So the first question here is from someone just asking that their soon-to-be ex has sent a Form E to the court late and hasn't taken any copies. They're reluctant to give them theirs as he will have the upper hand in the courtroom with arguments planned, etc. And she asks, will I be penalised for not giving him a copy? Any advice gratefully received? And Trina, I didn't know if that there was a second question also about a Form E. So I don't know if you want me to hit you with both at the same time.
It's very similar in nature, so I can deal with that in the round. So just to sort of echo what Ayisha said, I'm not giving specific legal advice on these individual cases because obviously we don't know the actual circumstances, but just a very brief explanation of Form E. That's the financial statement. And if people want to look at one, it sounds a bit daunting, but you can simply put into Google Form E. It comes up on the government website and you can see it. And as Ayisha said, we're trying to make, also certainly the preference is to now make documents much easier and clearer to read. Same with the orders. So it does set it out very clearly what you should be filling into the form. And so if you're not legally represented, you will be able to understand it. It's something you can fill in. It asks for all your financial information, including all your bank accounts, your income, your savings, your pensions, any investments. And then it also looks at what you need to live on, or what moving forward, what you would need, what your capital hopes are, what sort of house would you like to live in. Obviously, you need to be realistic on that. We'd all like to live in, a huge mansion, but if the matrimonial pot doesn't allow for that, we need to cut our cloth. But yes, it's a very, very clear document that you form that you fill in, and they will ask for statements in support of that. So you might need to add in bank statements, you might need to add in your wage slips. So it's just what it is for the other side, your soon-to-be ex, so that they can see exactly what the financial position is. So you may have pension that they don't know about, or you may have shares that they don't know about. So it's really important to be very transparent, very truthful, very clear on that. And in fact, it does set out on the form that they're expecting full and frank disclosure on that document. And there are very, very serious sanctions. There is a very clear warning that you could end up in prison for fraud if you don't complete the form properly. So it doesn't mean to say that everybody does complete the form properly. We've had a number of occasions where they don't complete the form properly, but that's a different scenario. But so it's really important that you fill that in. And then when the court write to you, if you're not represented, they will say, complete the form, send it to the court, and then contact your soon-to-be ex, and then you can do an exchange of that for me. So if you're the wife, the husband will send you yours, and you'll send him yours. And then you've got an opportunity to look through it in detail. And then you've got an opportunity to raise a questionnaire. So there may be things on there that you think, oh, well, I didn't know about his pension, I want some more information about that. Or you can raise any questions in relation to what's on that for me. And in fact, before you get to the first appearance at court, the court will have expected you to have drafted some questions about that. If you're not represented, just a tip that those questions are genuine questions in relation to for me. I think some people think it's an opportunity to go ask about, perhaps an affair that they were having, or, something else. But so those questions won't be allowed by the judge if you get to the first appearance. So the questions have to be related to the financial information that has appeared on the for me. But so we have to have this before the case can move forward, because unless we know this, it's going to falter at the first hurdle, because we'll get to the first appearance and we'll be saying, well, what are your pensions worth? Do we need a pension report, for example? If it's £5,000, then we probably don't need a pension report. But if it's £500,000, we will need a pension report probably. So it's really, that form is so important. It forms essentially the backbone of your case. And it will be referred to throughout the proceedings. And if, well, hopefully you don't, but if you ended up at a final hearing, it can be referred back to. So it's really important. I would advise people to take legal advice if they can afford it. We all appreciate it. It's expensive. But I've had so many cases where the outcome would have been vastly different had they not have been represented. So it's really, really important to get that for me right, even if you just sort of speak to a solicitor about just completing that, or you can complete it and get them to look over it. That's the first thing I would say about the for me. The other documents you would need to have before you go into the first appointment hearing is the court will expect you to have your questionnaire that I just mentioned. They will also expect for, if you've got a family home that you own that's not rented, obviously, they will expect that to have been valued. They will also expect to see what your mortgage raising capacity is. Can you raise money to buy somewhere? And they also like to see what you would like to live in. So if you think, your budget to rehouse would be £300,000, they would like you to provide some property particulars to say, these are the sorts of properties I can live in, and this is how much they cost. So they're the things that the court like to see. I can't sit here and say every first appearance I've done, we have all of that. That's a new directions coming our way, that we need to have all that, and we're not quite up to speed with all of it yet in some cases. But what they're trying to do is make the process as short as possible and as most cost effective as possible. And in that first hearing, the judge, as I say, will go through, and if there's barristers representing or solicitors representing, they'll go through the questionnaire and say, these questions need to be deleted, they're not appropriate. There is what's called the accelerated procedure now, and that's largely come from COVID, where if it's a very straightforward case, there's no pension reports needed, for example, or there's no business valuations needed, and everyone's in agreement, then that we don't need that first hearing. So that's obviously saves costs because you don't need to pay for a court hearing, representation, etc. So that there is a possibility of not having that first hearing. But going back to the Form E, if we don't have the Form E, it can't move forward, essentially. It doesn't mean that it doesn't move forward, because sometimes people just simply refuse to fill in their Form E. And I've had quite a few cases like that where they've just said, I'm just not going to do it. I can't do it. I'm not in a good place, or I just can't fill it in. Then what normally happens is we ask for what's called a penal notice if I'm representing the person who has complied. And what that means is essentially that other person can go to prison potentially if they don't fill in the Form E. And more often than not, the spouse who is the one who has complied will say, look, I don't want them to go to prison. I just want them to fill in the Form E. I just want this to end. So what we do is we try and move forward, and ultimately we can sometimes end up at a final hearing. And I've had this where they still haven't filled in a Form E. But what that means is the judge will then, or we will ask the judge to draw what's called inferences, to say, look, they haven't filled in the Form E, they're probably hiding assets, that's why they haven't filled it in which case, if I'm for the person who is complying, we would normally ask for most, if not all, of the assets, because we'll say, well, the reason they haven't filled it in is because they're hiding assets. So so that is a really stark warning to people. If you don't comply, it can be very, very detrimental. And it may be that you're not hiding assets, but that's an inference that the court can draw. So it's really, really important to comply with those directions. And the best practice, obviously, is to exchange them simultaneously. If the other side's not complying, I would strongly advise you, if you're represented, your solicitor will be doing this anyway. But if not, then it's something that you must do is keep documentary evidence. You have to email them and you have to say, I'm ready to exchange my Form E. Are you ready? And don't just do it once, sort of do it a number of times, maybe weekly perhaps, and just say, what's happening? I'm chasing you. I need you to complete the Form E, because what will happen is when you get to court, there can possibly be cost implications. So as a general rule, in these sort of proceedings, that each party pay their own costs. But if one side is acting in a way, what we call litigation conduct, if they're not complying and ultimately costing the other party money that they don't need to spend, applications for costs can be made. So you need to be seen to be doing everything you can be. As I say, document it all and say, I've tried to exchange Form Es, they're not willing to do it, or I haven't heard from them, there's been no response. So as long as you can sort of show that you've got everything done that you should have done, then the court can't criticize you for that. So you just have to be seen to be doing everything right, essentially.
Yeah, absolutely. There's only so much you can do, isn't there?
Yeah.
No, that's really helpful. Thank you. And the Form E, like you say, I can see why some people don't fill it in, because it is quite a daunting form, isn't it? When you print it off or you see it on the screen, it is quite daunting. But we always say to clients to just do a little bit, little and often. So just do a couple of sections at a time. You don't have to tackle the whole thing at once. You can just go through it section by section. You've got plenty of time. A court doesn't order it and direct it for it to be filed and served the next day. You've got plenty of time. Make a start and just make your way through it. Yeah. Thank you. That was really helpful. So the next question we've got here is going on to pensions, and this person's question is: should the pension on divorce expert's letter of instruction request the report be to the current date or date of separation, please?
Okay, again, I'm going to give a bit of a general answer to that, because the answer is it depends. And the reason it depends is because it depends how long have you been separated. We have cases where people have been separated for 20 years, in which case it should go from the date of separation potentially. But we've also had people who've just very recently been separated. And so what I would say about that is, certainly if it was a first appearance and this issue came up, if you've been separated for perhaps a long time, or you've put if you're for the person who's put significant amount of money into the pension post separation, or indeed premarital. So if there's significant premarital accrual, so they may be 50 years old when they get married, for example, and so they've got a significant premarital accrual. I would sort of say to the judge, look, can we please have, so when they do the report, can we have it so it's the whole thing generally, but also premarital accrual and post-separation accrual. So the report would be sort of essentially give you options. So they will say, look, if you take out the bit before they were married, it's this, and if we split it, and this is how we share it, it's this amount. Or if you take in the whole amount, it's this amount. So there are options to ask for, but that would have to be agreed either by the judge or by the other party. The thing I would say is, and looking at the sort of most recent PAG reports, which are the Pension Advisory Group reports, if it's what's called a needs case, so if there's loads of money sloshing around, there's loads of pensions on either side, this probably isn't relevant. But if there isn't, if you've had a sort of more traditional situation where perhaps one of the parties has stayed at home looking after the children, the other party's worked throughout their life, and they've got a pension, the courts will be looking at the pensions, how we're going to share them essentially, and what do both parties need. And if it is what's called a needs case, then they're less likely to sort of siphon off pensions. They would probably take the whole pot into account, but that's very fact specific, so I can't answer that in relation to the question. But it depends. I'm sorry, it's not a great answer, but yes, there are options, and it may be worth, if you're certainly if you can agree it with the other side, ask for the pension report in your letter of instruction, ask for different options, and then you can look at them. And very, very regularly we're in court saying, I think it should be page, the option on page whatever, rather than the option on the other page, because we think that's more appropriate. So it's not uncommon to have various different options when you get the report, the pension report.
Yeah, absolutely. And the pensions experts deal with this quite frequently, so they'll be used to knowing what to do and what's being asked for and how to deal with those sorts of things.
Yeah, exactly.
Okay, so the next question is quite a long one, but we're just going to break it down a little bit. And it's someone just asking the following. My father-in-law gifted myself, my young daughter and my ex-husband premium bonds. They have sold my daughters and ex-husbands and gave the money back to my father-in-law. What can I do about this, as I feel they are purposefully moving assets because of the financial resolution dispute? So just about, moving and hiding assets potentially.
Yeah, and that question goes on. I'm assuming this is the same person, because they also asked about property. So I was just going to deal with that as well, because I think they say in that one that that the father-in-law had gifted a property to her ex-husband to buy a property before they got married, and he signed a form from the bank saying it was a gift and that he'll have no interest. But now the father-in-law is saying that he has got an interest. So so a couple of things on this is that we see this quite a lot. We call it bank of mum and dad. So you'll be in a situation where someone will have gifted something to one or other of the parties, or both of the parties. And if it's a house, for example, they give money for a property or a deposit for the property. It's very difficult to get on the property ladder without some help from parents. So they're in a situation where they've been given money, and as he says, they've ticked the form to say that this is a gift. And I think that's largely because mortgage companies won't allow someone else to have a first charge on a property, for example. So you have to tick the box to say, oh yeah, this is a gift, I don't want it back. But then what happens is, sadly, the parties end up in a divorce situation or a separation. And then the parents will very frequently say, well, that wasn't a gift, that was a loan, I want that back. And the reason they're doing that is to try and protect their children. And the instinct, to say with the premium bonds, they try and sort of draw in as much money as they possibly can to try and protect it. This is really, really common, I have to say. We do see this a lot. This is not an unusual situation, and people trying to shore up their position, perhaps after the horse has bolted, because of course if they'd have done pre-nups or even post-nups, that might be slightly different, but I don't want to get involved with all of that. But with this situation, it can get a bit technical, and again, I would have to say you really do need legal advice on this. So normally with financial remedy hearings, we have 3 hearings. So we have the first appointment, which I've referred to, that can be foregone for the accelerated procedure if parties can agree. And then we have a second one called the FDR, which is essentially a hearing where parties negotiate. And they get an indication from the judge to say, if this ends up at a final hearing, this is what I think will happen. And that helps the parties negotiate. That whole hearing is without prejudice. So you can make offers in that hearing. You can try and settle it, but you're not stuck with that if it doesn't settle. And the other thing about that is the whole thing, what the judge indicates is not binding. So at the end of that FDR, it's normally a long day, but if the parties can't agree, the judge won't make a final ruling on it. And if the parties can't agree at that, then we end up at what's called a final hearing. And at that final hearing, the judge will hear evidence, the parties will be cross-examined, they'll go through all of the financial evidence they have before them, and then the judge will make a ruling. And at that point, that is binding. So that's normally what happens. However, if we have people saying, well, hold on a minute, that house doesn't belong to the parties, that belongs to me, or a chunk of that house belongs to me as the parent, I've given them £50,000, £100,000, whatever it is, I want that back, then they would become what's called interveners. And so the courts say there's no point in having the FDR hearing, the second hearing, because we don't know what we're negotiating with. Are we negotiating with, for example, £500,000, which is the proceeds of the house, or are we negotiating with £400,000 if, for example, the parents are saying we've lent them £100,000? So we have what's called a preliminary issue hearing. Ideally, these are to be avoided because they're expensive. They add time onto the process, but a lot of times they're going to be unavoidable. And so what you have is a situation where it's like a mini trial, basically, and the court will hear the evidence just specifically on the interveners. So has, for example, the husband's mum and dad lent money for the house? And if they have, was that a gift? And if it's a gift, then that money remains in the matrimonial pot. If they can prove that it wasn't a gift and it was a loan, then obviously that then gets deducted from the matrimonial pot, and then the proceedings move forward in the usual way, but knowing what the actual value of the pot is. And it's completely fact specific, it's completely evidence based. If there's a formal loan agreement, for example, that all the parties signed at the time, we're going to lend you £100,000, for example, but we want this back, this is the interest we want, this is when we want it back, then you're in a stronger position than, my parents just sort of transferred the money into my bank account. So that is completely fact specific. So in relation to the question, that it sounds to me that you're most likely going to end up in sort of some preliminary issue kind of territory. If it's a small amount of money, I mean, I'm talking about, I've just been referring to £100,000. If it's a small amount of money, it's not going to be worth doing the preliminary issue because it's going to cost you more to do the preliminary issue hearing than it is to argue it. And what we sometimes do with that is, if we can't settle it at an FDR hearing, if it goes to a final hearing, then that party can do a witness statement perhaps and say, look, I lent them the money, this is how much it is, I need it back because of X, Y, and Z. So for more significant amounts of money, you'll end up at a preliminary issue. And so obviously we don't know how much they're talking about here. But in terms of the premium bonds, the parties are under a duty not to dissipate the assets wantonly, and that's the test. There's got to be wanton dissipation. So say, for example, someone's taken it and sort of spent it, and the court say yes, they wantonly dissipated it, then if you're on the other side, you can ask for what's called an add back. So you say, look, I want that money essentially theoretically added back into the pot. Even though it's probably been spent, you can ask for it to be added back, and then you can sort of say, well, I need my share of the full amount rather than what's left, for example. It's quite a technical area of this area of law, and again, I would just say really do need to get legal advice. But as I say, it's something that is very common, I'm afraid, in these sorts of proceedings.
Yeah, absolutely. Like you say, I think everyone has the bank of mum and dad to help with the first house, so it is common. Or even if parents help with the first house and then a couple to go on to sell the first house and go on to the second house, the parents still hold on to the money that they gifted, 1 or 2 houses ago, and that sort of rises out of the past. So yeah, absolutely, it is really common. Thank you, that was really helpful. So the next question is, well, there's actually a couple that we got sent in about that sort of hiding assets, and I think you've covered that in what you've been talking about.
Yes, there was one question where they said, what are the consequences if I think it's her husband, she suspects he's sort of transferring money into perhaps his mother's account. What are the consequences? Well, sort of as I said, there are when you fill in the Form E, there's a very clear warning that you are committing fraud if you fill this in incorrectly. So that's the first thing to say, and obviously then that would be a criminal matter if you're committing fraud. And how it would be discovered, we can instruct experts, things like forensic accountants that can look through the statements, what they provided, and pick up, inconsistencies, so on and so forth. So I would just say to anybody going through this, please don't try and be clever and think, oh, I'll hide, some cash under the bed or anything like that, because they won't know about it, because there are really, really serious sanctions if that's found out. And also it just means it calls your whole situation into question. A judge would take a very dim view of that. And so again, we ask for draw inferences. They've hidden that. What else is there? That sort of thing. So it's really, it's just so important to be transparent and honest, because it's just not, for the money you're going to save potentially, it's just not worth it. Just deal with it. The courts will deal with it fairly, and don't run the risk of sort of being charged with fraud for not filling in the forms properly or trying to hide assets.
Yeah, absolutely. So the next question is about a final hearing. Someone's got a final hearing scheduled for early October, and part of the prior order stated that the parties are to exchange their narrative witness statements dealing with factors set out under Section 25 of the Matrimonial Causes Act by 4 weeks prior. Is this the same as the position statement for the FDR, please?
Okay, yeah. So no, it's not. In the short form, no, it's not. So a position statement is where you set out your position, essentially. That's all it is. And so as barristers, we draft them for our clients, and we say, this is what it's written in the third person, this is what they're saying, this is what they want to happen. And that changes from hearing to hearing. So the first hearing is very different to what we say at the FDR, and then that could be potentially quite different to what we say at the final hearing if we get that far. Whereas the witness statement, it's written by, or it's in a first person, so it's written by you, and it is there's a declaration of truth on there to say that you're telling the truth. It's signed by you. It's a very different document. When I draft position statements, my clients don't sign them. There's no declaration of truth. Whereas a witness statement is your sworn evidence, essentially. And so when you look at, or what the courts will look at when they're at a final hearing, is who needs this money? Where does this money go? Most cases are needs cases, even if there's quite a significant pot. Obviously, if you've got millions and millions and millions and you're arguing over who has the ski chalet in Verbier, or that sort of thing, that's slightly different. But for most people, and most people we deal with, these are needs cases. And so what you have to look at is Section 25 of the Matrimonial Causes Act 1973. Again, you can just Google that, it will come straight up. And then you just need to go through the criteria in there. It's really clearly set out as to your position in terms of why you need the money and what should happen to the money. So it asks things like, I've just got it in front of me, it will talk about the income and earning capacity of each other. So you need to go through, this is my income, this is why my income is this, this is why it can't be any more than this, and also what your other sort of resources are. So if you're cohabiting, for example, can your new partner give you some money, or have you got parents who will give you some money? It's very rare that you'll have people offering that there's someone in the woodwork who'll come and give them money, but it does happen. And then part of the Section 25 criteria is the financial needs, of which you're likely to have or now or in the future. The standard of living enjoyed by the family, the courts can take that into consideration. Did you live in a detached house, or were you in a one-bedroom flat? Did you go on luxury holidays every year? They'll take into account your age, the duration of the marriage, any physical or mental disability of either of the parties, contributions which the parties have made, the conduct of each parties, and that's essentially it. But you can literally go through, if you just, as I say, you can just Google Section 25, Section 25(2), and it will come up with the criteria, and you need to use that to go through your statement. And you say, I'm this age, my partner's this age, there's perhaps a discrepancy in ages. I successfully argued that my client should keep all of his pension the other day because he was, I think, 15 years older and he was at retirement age than his wife. So you can talk about that, why you need as much money as you say you do need. But then under Section 25(3), what the courts have particular regard to is the financial needs of the children. So the courts will put the children first. Where are they going to be housed? How are they going to be housed? Does it need to be near their school? That sort of thing. So you can go through that. You can look at that and you can refer to the children as well. So you can say, look, I've got 2 children. I need a 3-bedroom property. It needs to be in this area because it needs to be near the school, etc., etc. So that's all that is, but that's very different to the position statement. And what happens when you get to a final hearing, the judge will have read that statement, your Section 25 statement, and that will stand as your evidence. So occasionally you could be asked a couple of supplementary questions. If you're represented, your barrister might say, I just want to clarify a couple of those points. And then you will be cross-examined on that statement. So you don't need to read that statement out because the judge will already have read it. And if you're represented, obviously your solicitor will give you some assistance. It's ultimately your evidence, but your solicitors can help formulate the statement. But it's a really, really important, again, it's a very important document because that's what the judge will be looking at, your evidence. How much do you need? Where do the children need to live, etc. You can still, so at a final hearing, you have your witness statement, but you can still do a position statement. So you've done your witness statement, but what your position statement can do is consider the evidence of your ex-partner, your ex-husband, and talk about, what he's saying. He's saying this, but I don't agree because of this, and this is why I need the money, and so on and so forth. So you can sort of put a bit more arguments in your position statement, but set out exactly what it is that you're seeking, and why the court should go with you. So they're 2 very different documents.
Yes, thank you. Yeah, and the Section 25 statement, that's your chance to put forward all your arguments, everything that you want to, why you're asking for what you want. Basically, you summarise that really well, Trina. So thank you. It is an very important document.
Yeah.
Okay. Are you happy to answer one more, Trina?
Yes. Yeah.
Yeah. Perfect.
And they're quite brief, actually. So yeah.
Perfect. Okay. So there's one here. Someone's just asking for some advice. He's selling the house, and I presume his partner needs more of a deposit to get a bigger house than he does. So she needs 130,000 for a deposit on a house. She wants to leave him with a bit less that, and they've come to an agreement together to offset that against maintenance. So it sounds like they've come to an agreement that suits them, and they know what works for them as a family, and he's just asking if that arrangement can be upheld, or could his partner change her mind at a later date.
Okay, so first of all, I want to say that is such great news that they've been able to come to an arrangement that they're happy with. That's great. The only thing I want to say, yes, of course, unless you've got it formalized in a what we would call consent order, either party can change their mind at any time. But when they change their mind, you could be in a very different financial position. You could, I don't know, for example, win the lottery. What I would say to you is, if you've come to an agreement that you're really happy with, go and see a solicitor. You can get a solicitor to draft it for you. Say, this is what we're doing, this is what we're happy with. The solicitor will draft it, and then it'll be sent to the court, and then a judge will look at it. And again, it's not uncommon for a judge to look at it and say, well, hold on a minute, that doesn't feel quite fair because they're getting this and they should be getting that, or whatever it is. But the judge will look at it. If it's fair, the judge will then approve it. It will then be sealed, and then it would be very hard for your partner to then change her mind, unless there's a change in circumstances, or, for example, you haven't told her the full picture from the outset. There are ways to possibly reopen it, but that will give you a lot more security than it would if you just sort of came to a bit of a verbal agreement. Yes, they absolutely can change their minds.
And it also means that it's enforceable. So once you have that order, it's enforceable, and you have got some standing behind it. Which is another positive and another sort of selling point to getting a consent order.
Yeah, exactly. So yeah, and everyone knows where they stand then, and there's no sort of grey area. And as Ayisha says, the order should be very clear. It'll be drafted in a way that everybody should understand it. So
yeah, and it also severs those financial ties between the couple. I think people don't really realise that unless you have that order, it could be a very simple, clean break order. No one's really getting anything, and they're just sort of parting and both staying in similar financial positions as they were before. But unless they have that, their financial claims are still open to each other. So it's really important to have that, just to sever those ties.
Yes, and although at some point, we see it a lot, that at this point everything's fine and we're getting on really well, and we've agreed that I'm not going to go after your money, you're not going after mine, and we're all happy. But then when circumstances change, you might meet a new partner, move in, get married, whatever, things can change. And so it's best to, if you can come to an agreement, that is ideal, but do get it formalized through the courts, I would say. And as I say, it doesn't cost a lot of money to get a consent order drafted up, but it can potentially save you a significant amount of money in the long run.
Yeah, absolutely. Okay, so we've got the last question here, and I'll just read that out. So they're asking, how should I handle the situation with my house? I co-own a house with my ex. We have a mortgage, and he's asking to discuss what to do with it. For context, he's now living with the woman he had an affair with. His suggestions so far are either to sell the house or turn it into a rental property, as he's focused on making money. If we sell, we won't make a profit after covering the costs of breaking the mortgage, but I don't think he realizes this. I'm also worried about the possibility of making my 6-month-old daughter and myself homeless. I've been talking with my family about the option of adding someone else to the mortgage, as I can afford to manage the house on my own, but I don't meet the eligibility requirements. Does anyone know if adding another person to the mortgage would result in additional taxes, like those associated with a second home?
So first of all, I'm not a tax advisor, and I can't advise in terms of tax. I simply don't know. But what I would say is that it comes back to the Section 25 criteria. The first and foremost concern of the court is going to be the children. So you're saying I could find myself in a situation where I'm going to make myself and my child homeless. So what I would say about this is there are situations where you can possibly remain in the home if that's going to be affordable. It's called we do things what's called a measure order, which means that you can remain in the home with the child until there's a trigger point, and that could be until she turns 18, or you remarry or cohabit, or one of those things. So the first and foremost, you need to think about yourself and being able to stay somewhere that you can actually live securely. But I think you need to get tax advice. I know there are, people can become guarantors on mortgages and things, but that would depend on your earnings. Have you got mortgage raising capacity? Can you take over the mortgage? But if you can't do any of those things, then there could be a situation if your ex-spouse would agree that you could stay in the property, and then when one of those trigger points happen, you could then potentially then divide the money then. But obviously that would have to be a discussion that you would have to have and hopefully agree. But yes, don't worry about him making money. Think about yourself and the child first and foremost, I would say. Take some legal advice.
Absolutely. That's great. Thank you. That's really helpful, Trina. So thank you for answering those questions.
Can I just raise a point on that last question? Obviously, we're assuming they're married, but obviously things would be quite different because it just says my ex.
Mhm.
So it'd be quite different, obviously, if they weren't married, wouldn't it? The law that would be applicable to them, claims
Yes,
she would have.
yeah, absolutely. That's probably beyond the remit of this one. We'll have to save that for another day. But yes, although that area of law is looking to be reformed because more people cohabit now than ever. So they are definitely looking to reform that area of law because it's just not, it's clearly not fit for purpose as it is. But yes, absolutely. I'm assuming that they're married, but obviously that would be very different. Again, to take some legal advice, because there are things you can do even if you're not married and you've got children. So there are applications that could be made.
Thank you. Just wanted to clarify that for everyone.
That's great. Thank you, everyone. And thank you so much for joining us today on the Breakup Breakdown. We've really enjoyed having you, and we hope that people have really taken on really helpful information from you guys. So yeah, we're really grateful. And thank you so much.
Well, thanks so much for
Yeah,
having
thank
us.
you.
It's been really
It's been
enjoyable.
great.
Thank you very much. It's been brilliant. Thank you.
Thank you.